Good morning, my name's Catherine Fagan. I'm HR Manager for Diversity here at the university, and I'm responsible for organising the Diversity Festival. So I'd really like to welcome students, staff and external visitors to the University of Chester Diversity Festival event. For a fortnight each February, the university holds a diversity festival which plays host to a range of events featuring guest lectures, conferences, lots of fun event training, seminars, films, all sorts of things. And the festival's open to staff and students and visitors from the local community and from other organisations. So each festival addresses a new theme, and we try and keep each festival engaging and interesting with different events. So this year we've decided to focus one of our events on employment law and the Equality Act, given that that's new legislation. So our conference today, Equality Law, Past, Present and Future. I'd like to welcome our first speaker, who is David O'Hara, who's a Senior Associate from Eversheds. So we're very pleased to have David, who, as I say, is a Senior Associate and works as a member of the Eversheds employment team, advising clients on both contentious and non-contentious matters. David's advised clients on a whole range of issues, including strategic and day-to-day people management issues. So this includes advice on complicated areas of discrimination, grievance, tube transfers, disciplinaries, ill health, capability and so on. And David's also heavily involved in drafting and advising on employment contracts, HR policies and procedures, compromise agreements, tribunal claims, providing tactical advice, conducting tribunal advocacy. I could go on and on. So David was a founder member of the Eversheds Employment Law Training Team and regularly delivers a whole range of training sessions. So we're really pleased to welcome him to the event today. So I'll hand over to David. Thank you very much.
Thank you. Morning, everybody. What I've been asked to do in my slot for the next half an hour or so is just say a little bit about what the Equality Act 2010 means for employment lawyers. And the way I thought I'd do this was try and explain, I suppose, the key changes that the Equality Act has introduced. It was brought into force in on the 1st of October 2010, at least most of it was. There are some bits that are still to come into force. What I think is worth noting is that actually the purpose by and large behind the Act is to sort of harmonise and bring together all the different strands of discrimination legislation that we've had for some time in the UK. So over a period of since 1975, when the Sex Discrimination Act was introduced, we've had legislation first of all on sex discrimination, then race discrimination, disability discrimination, sexual orientation, religion, belief and age. And because those have been introduced at different periods of time, whilst there have been some similarities between them, there have been quite a few differences. Also, law has changed a little bit, cases have interpreted the law. And the idea, therefore, behind the Equality Act is basically to put all discrimination law in one act. Most of it, as I say, is really what we had before. There are, however, some key changes which I thought I'd flag up, and also give you an outline of the fact that there are still some parts of the Equality Act which are yet to come into force. You've got a handout of the slides. I'm not going to go through it, obviously, on a line-by-line basis, but what I will do is pick out the key issues. So in terms of what is new and what is now in force, there's new terminology around the legislation. So we talk now about protected characteristics. And I'm going to cover all of these points off in the slides as I go through. Indirect discrimination, and I'll explain what that is, has been extended to some areas that it didn't previously cover. We've also got some changes to the legislation around disability discrimination. So although we've had disability discrimination in the UK since 1995, there's some quite important changes in respect of that in the Equality Act. Also what we term associative and perceptive discrimination, and again I'll explain what we mean by that, extended by the Equality Act. There's the introduction of something called third-party harassment, and also a new provision aimed at disability discrimination around what are called pre-employment health questionnaires. So I'm just going to explain what all of those are. The Equality Act, because it puts all discrimination legislation into one piece of law, now talks about what are called protected characteristics. And there are 9 protected characteristics under the legislation. So there's age, disability, gender reassignment, marital or civil partnership status, pregnancy and maternity, race, religion, belief, sex and sexual orientation. Those are not new, those were all covered under the previous 6 pieces of legislation, but the reason they've now been divided up into 9 is although most of the Equality Act applies to all of them, there are some bits which provisions don't apply to. There's also power in the legislation to add in discrimination on grounds of caste to the definition of race. There is an argument that race, in the way it's drafted, already covers that, but the government has allowed itself the ability to bring that in separately. We don't yet know at the moment whether that's going to happen or not. There's also been a small change to some of the previous definitions. Previously, someone to bring a claim of gender reassignment had to be in a situation where they were intending to, were undergoing, or had undergone a process for the purposes of reassigning their gender. And there was previously a requirement that that could only be protected if it was being done under medical supervision. That now has been removed, so in theory it therefore covers somebody who decides they simply want to live the rest of their life as someone of the opposite sex without having to go through any medical processes or medical supervision. There's also a small change to disability discrimination. It used to, under the 1995 Act, give examples of where people might be discriminated against in terms of their activities, things like speech, hearing, eyesight, those sorts of issues. That, what was termed the capacities, has been removed. The definition of disability, which is a substantial and adverse long-term effect on someone who has a physical or mental impairment, remains unchanged. So a small alteration there. Let me move on just to say a little bit about the different types of discrimination, which are broadly unchanged. Direct discrimination is where someone is treated. Previously it used to be called differently on grounds of someone's sex, race, etc. There's been a slight change in the definition here, so it talks of because of a protected characteristic. So if someone is treated differently and they can show that that is because of their sex, their race, their gender reassignment, whatever it may be. Whilst because of may not seem an immense important change or definition, what it does do is it makes it clear that in most cases now it extends the legislation to cover what's called both association and perception discrimination. And prior to the Equality Act 2010, some bits of discrimination covered this, some bits don't. So what we mean by association is I don't have to actually be of that particular race, gender, religion, belief, if I'm being treated less favourably, I say, because I'm associated with somebody who has that protected characteristic. So an example of that would be an individual who claims that they've been treated less favourably, not because they've got a disability, but because they've got a disabled child, and that perhaps causes them some working issues. Or that comments are made to them about their disabled child. It's not directed at their disability, but it relates to somebody else's disability. Or somebody is discriminated against, treated less favourably, because there is a perception that may not be true. So there is a belief that someone is gay and they're not. It doesn't matter under the law whether they are or not. If that is the reason they are being treated less favourably, that is sufficient. And I say what the Equality Act did here was to bring into line the areas of the protected characteristics to cover that, apart from marital status, civil partnership and pregnancy, which are not included within perception and association, but are included within direct discrimination. Next type of discrimination is something called indirect discrimination. Now, I've put up on there, just so you've got it if you're not aware of it, the definition, which, as all these legal things are, can be slightly complicated. In essence, indirect discrimination is different from direct discrimination. Indirect discrimination is where on the face of it everybody is treated the same, but the impact of that treatment is different because of someone's race, sex, religion, belief, etc. So, for example, if an employer was in a situation where they wanted to change people's hours of work, so people had to work weekends, work at nights, whilst they might be introducing those changes for everybody, so everybody's treated in the same way, that could cause someone more of a problem because of their religion and belief, They may be unwilling or unable to work at weekends or those particular hours. It may affect someone because of childcare arrangements. So there is an impact on a group of people who share a protected characteristic. The definition itself remains unchanged, and the bit at the bottom there about a legitimate aim basically just says that people can actually be discriminated against on this basis if there is a good reason for the change that's being introduced. So is there an overriding reason, in the example I've given, why employees have to work more flexible hours? And have they been consulted with? Have alternatives been considered? What the Equality Act did do is extend indirect discrimination to gender reassignment and to disability. It previously didn't apply to those areas. One of the areas where the Equality Act has made, I suppose, the biggest change is under disability discrimination. And somebody who claims that they've been discriminated against because of their disability has 4 areas on the face of it that they can bring a claim. The first one there is the direct discrimination. I am treated in the way I am because I have a disability. The bottom one there is indirect discrimination. So applying some sort of provision that someone with a disability is going to be more difficult to be able to achieve, for example. The third one is called reasonable adjustments. Again, there's no real change under the Equality Act in respect of that. The concept behind reasonable adjustments is that employers should make changes insofar as they are reasonable to accommodate someone who's got a disability, and that could be providing them with, for example, help, support. It could be in a student context, giving someone more time to complete an exam, for example, or complete an exam in a different way. And again, as I say, those provisions remain really unchanged. There is a new provision under the Act, which is the second bullet point there, detriment arising from the disability. Now, again, I've put the definition up there, but what this basically aims to deal with is a situation where somebody says, well, you didn't necessarily treat me in a different way because I have a disability. It's really the consequence of that disability. So again, if I give you an example, let's say you have an individual who works for an employer and they are off ill. And the employer perhaps has a policy that deals with sickness absence, that follows a process that could lead to the individual having their employment terminated because of excessive periods of absence. Let's say I've got a disability and I'm off for a period of time and my employer dismisses me. As long as my employer would dismiss other people without disability who took similar levels of absence, I can't claim direct discrimination. The reason I've been treated as I am is not because I've got a disability, it's in essence the absence. And therefore there's a potential gap here in the law. So what this piece does is it then introduces protection here which says, well, okay, why was David dismissed? He was dismissed because he was off ill. Why was he off ill? He was off ill because he had a disability. And that therefore is sufficient to link that in to this particular provision. Again, though, very importantly, point at the bottom there, the middle point there, first of all, is this can be justified. So is there a good reason? So what was the prognosis in respect to the person's absence? Did the employer look at how long before they would be back at work? Was there any consideration as to how likely it was that their absence record improved? And also under this, someone cannot be guilty of disability discrimination if they did not know or should not have been expected to know that the individual did suffer from a disability. So if it's not known and there was no reason it should have been known, because perhaps of what the sick notes are saying, then that does not cover this provision. So that's an area where disability discrimination has been extended. The other area of disability discrimination which is new relates to something called pre-employment health questions. The logic behind this was to try and reduce the ability of employers to perhaps weed out people in a recruitment process by asking for their medical information. And therefore what this seeks to do is in certain situations make it potentially unlawful for employers in a recruitment process to ask about someone's health or disability before offering employment to that individual. Now, there are several important things just to mention about this. Firstly, it's before offering employment. So it doesn't prevent an employer offering someone the job subject to satisfactory medical records or an appointment or a report. Of course, if that report is obtained, it suggests there are health problems. Then if the individual is not recruited, the normal provisions in relating to disability could apply anyway. So it doesn't mean that it's necessarily okay for the employer to say, right, we're not taking you on after all. What it does mean is it doesn't fall foul of this particular provision. So this is aimed at sort of shortlisting processes. On the face of it, though, it could be argued that it's a fairly limited power because the EHRC, which is the Equalities and Human Rights Commission, which is the body that oversees discrimination legislation, on the face of it, they are the body that's given the power to bring a claim under this. So they could bring a claim against an organisation saying you breached the legislation. However, where there is a twist in the tail is that an individual who then is unsuccessful in their job application could bring a claim of disability discrimination and argue that because this question was asked, that is why they did not get the job. And if such a claim is brought, then what's called the burden of proof is reversed. So the burden of proof is if someone brings a claim of discrimination, who has to prove that? The basic rule is an individual bringing a claim has to prove that they were discriminated against. And that can sometimes be quite a difficult thing to do. What the law does here is it says, well, if the employer has asked these questions, which it shouldn't have done, and the individual then does not get a job and brings a claim, it's actually for the employer to prove that they did not discriminate. So that's actually quite important from a proof point of view. The law doesn't say you can't ask any questions before offering employment. It says you can do only in certain circumstances. So where there are reasonable adjustments needed in the assessment for the job. So for example, if there is some assessment process that the individual has to go through as part of the decision whether to offer people the job, then it's perfectly legitimate to ask whether there's any reasonable adjustments that need to be made for that individual because of any disability they have. The second one, which I think is fairly obvious, is it's perfectly legitimate to ask this question if it relates to something important in terms of the job that they're going to do. So if the nature of the role means they must be able to do certain things, which from a health point of view there could be an issue, clearly that's okay. And the example that's given in the guidance is an employer who's recruiting someone to work at height, so go up scaffolding, tall ladders, perfectly legitimate to ask whether they have any health problems that prevent them doing that. Because obviously, clearly, in those situations, it would be perfectly legitimate not to recruit that person, because the employer would owe a duty of health and safety obligations to them and to other people. For monitoring purposes, so that's monitoring applications and do we get an appropriate proportion of disabled people applying for jobs, that though should not be seen by people who do the shortlisting process. The purpose of taking positive action. Positive action is something that exists which allows employers to encourage applications from people who are perhaps underrepresented in the workforce. So it is legitimate for employers to say, we particularly welcome applications for this post from people over 50. We particularly welcome female applicants for this position. That can be done, but then there is an obligation to appoint on a best person for the job basis. Otherwise, it becomes something called positive discrimination, which is unlawful. There will be very rare occasions where someone can be recruited because they have a protected characteristic, and that's where it's called an occupational requirement. So in disability, for example, it might be legitimate for an organisation that is a body that covers a particular area of disability to recruit someone perhaps as a figurehead who has that particular disability themselves. So pre-employment health questions are new. Harassment isn't new, apart from the fact we now have a all-embracing definition. The law on harassment is quite an interesting area because originally when sex discrimination, race discrimination was introduced back in the 70s, there was no separate law in respect of harassment. So we had a number of issues about whether that was covered under the direct discrimination provisions. Then laws got introduced, changes were made, and now, with the exception of pregnancy, maternity and marriage civil partnership, harassment covers all the protected characteristics. Harassment is defined as unwanted conduct which relates to that protected characteristic. Conduct can be fairly wide, so it could be in extreme situations physical conduct, it could be verbal conduct, so comments I make, jokes I tell that I think are amusing but perhaps you don't. It could be non-verbal conduct, that could be sending emails to people, displaying offensive images. It needs to be unwanted. Unwanted basically means I know you don't want me to do this, perhaps because you've told me, or it should be so blindingly obvious that I should realise that you don't want me to behave in this particular way. Where harassment has introduced a new provision under the legislation is what's called the liability for third-party harassment. Prior to the Equality Act, this existed in respect of sex discrimination, but has now been extended to all the protected characteristics, apart from, as I say, pregnancy, maternity and marriage civil partnership. Let me sort of give an example of this. Let's say I go into Eversheds, who I work for, and I allege that one of my colleagues has harassed me. The law on that is relatively straightforward. I could bring a discrimination claim against that individual. I could also bring a claim against Eversheds as that person's employer. And what Eversheds would have to do would be to be able to show, well, we did everything we could to stop it happening. We had policies, procedures in place. Where there have been previous complaints, we've dealt with them properly. What happens, however, if I go into Eversheds in the morning and I argue that I've been harassed by a member of the security staff who isn't an Eversheds employee, who's employed by a third party, but happens to be on a contract to do security for Eversheds? That's slightly different. I could again bring a claim against them. I could potentially bring a claim against their employer. But to what extent could I say to Eversheds, you're liable for that? What the law says here, and it on first going through sounds slightly odd, is Eversheds is only liable for those third-party actions if they know that I have been harassed on at least 2 previous occasions and they failed to take reasonably practical steps to stop it happening. Now that might seem a bit odd because it almost makes it sound as if you get a couple of free ones first before the employer is then liable. What I would say is 2 things. Firstly, of course, any employer owes a duty of care to look after its employees. So if I make Eversheds aware of one action, they should, as an appropriate employer, be dealing with that anyway. And there could be potential consequences if they don't. But under the legislation, they're only liable under the Equality Act if they're aware that it's happened on 2 previous occasions. Although it could be by different third parties. So let's say I'm extremely unlucky. One day I come in and I'm harassed by the security staff. The next day it's the cleaning staff, who are also not Eversheds employees. And the next day it's the catering staff. Although they're from 3 different third parties, that is sufficient. And third parties is quite wide, so would include, for example, students. It would include customers, suppliers, visitors, a whole range of people. Anyone who's not an employee of the organisation itself. So that's just a sort of quick overview in terms of the key changes that we've had so far. I just wanted to finish off by just very briefly flagging up the fact that the Equality Act hasn't finished. There are provisions that are yet to come into force. One of those is something called dual discrimination. And the logic behind this is sometimes people might be able to argue that they've been treated less favourably because they have a combination of protected characteristics. The example given by the government when they were looking at bringing this legislation in is, for example, that a black woman may be able to argue that she is more likely to be discriminated against because she is a black woman. And therefore, if she only brought a race claim, she would have in that situation to compare herself with a white woman. If she brought a sex discrimination claim, she would then have to compare herself with a black man. Now, I have to say, my experience of dealing with tribunals, I think it's a little bit of a non-point, to be honest. And those of you who will be aware of the recent Country File case brought by Miriam O'Reilly, she was arguing this as part of a claim that she was discriminated against on grounds of age and grounds of sex. she actually succeeded on grounds of age, not on ground. She succeeded on grounds of sex, but not on grounds of. Actually, I'll get this right a minute. She succeeded. Sorry, I'll get this right. I knew when I started this. She succeeded with her claim on grounds of age. She didn't succeed in terms of her claim on grounds of sex. But the tribunal in that case, interestingly enough, said, had we thought that there was this dual discrimination, that she was treated less favourably because of these combination, we believe we could have found for her under the provisions as they currently are. So whether this provision actually comes into force remains to be seen. I'm just going to finish off with a little bit on public sector equality duties and repeal of the default retirement age, although it's slightly outside the Equality Act. Before I come on to that, positive action in recruitment. One of the slightly controversial proposals under the Equality Act was a provision which is coming in now on the 6th of April, which allows employers, in respect of recruitment and promotion, where there are two equally qualified candidates, to appoint the one because of their protected characteristic where they were underrepresented within the workforce. So in other words, if myself and a female employee applied for a position within Eversheds, and Eversheds took the view that they were underrepresented with female employees at that level, and that we were both equally qualified, they could appoint her rather than me because she's female and I'm male, and we should have a different protected characteristic. That has sparked, you probably saw there was quite a lot of controversy about this, suggesting that it was a requirement of employers to positively discriminate. The legislation actually only says if people are equally qualified, and I think that's going to be fairly few and far between, it is open to the employer to do this. It's not an obligation to do so. And we're awaiting some further guidance before it comes in April, just to clarify some of the provisions around that. Let me finish off with the 2 points that I said I'd come back to, one of which is public sector equality duties. Now, public sector bodies, which include educational institutions, have extra responsibilities under discrimination legislation. Not necessarily just to be reactive and to stop discrimination happening, but to be proactive in terms of doing things like looking at their policies, procedures, admissions policies, to try and avoid discrimination occurring in the first place. Currently, there are 3 areas where that obligation exists, and those 3 areas are gender, race and disability. With effect from the 6th of April 2011, that is going to be extended to cover all of those protected characteristics that I've listed there. So an increase in the areas to be covered. The general duties which are going to be imposed on such public sector bodies are to have due regard to the need to eliminate discrimination, to advance equality of opportunity and foster good relations between groups. And those are broadly what exists at the moment. They're slightly different under gender, race and disability, but in very broad terms what is still there. However, there is a bit more detail about what public bodies then need to do as part of what are called the specific duties to back up the gender duties, the general duties. So by 31st July 2011 and then annually, there is a requirement to publish certain information to demonstrate that they are complying with their general equality duties. And there are additional responsibilities on larger employers who have 150 or more employees. And I've set out there the sort of information which must be included in the publication that is required. There's also a requirement that by April 2012, employers prepare and publish objectives which it reasonably thinks it should achieve to meet its general aims, and details of how it's done that in developing its objectives. And for educational institutions, that is to cover not just staff but also students. The final point I just wanted to mention, although it's not part of the Equality Act itself, but does obviously impact quite substantially on equality, is the repeal of the default retirement age. So when age discrimination legislation was introduced in 2006, whilst that outlawed discrimination on grounds of age in certain areas, it did leave in the ability for employers to retire people on reaching a retirement age, and the law had therefore what was called a default retirement age of 65, and that still exists at the moment. There is a provision which allows organisations to retire people when they reach retirement age. There's a process that needs to be gone through which allows individuals to request to work beyond retirement age, but in essence, as the law currently stands, as long as the employer goes through the hoops, it can retire someone when they reach 65, even if they want to stay on. The government's reviewed this and basically announced that that default retirement age is going to be abolished with effect from the 1st of October 2011. It is still possible to retire people, therefore, who are due to retire up to the 30th of September 2011, as long as the existing process is gone through. In respect of people, however, who are due to retire after the 30th of September 2011, the current law means that those people can then, if they are retired, bring claims. At the moment, as long as the appropriate process is followed, there can be no age discrimination claim, there can be no unfair dismissal claim. That is going to change, I say, with effect from the 1st of October 2011, and that obviously means a fundamental review for many organisations as to what they are going to do about retirement. There may be some circumstances in which it can be argued retirement is justified or is not unfair, but clearly this is going to give people much greater rights in terms of retirement if they want to carry on working. So those are the areas that I wanted to cover off. I'm going to be around over lunch if anyone and over the break if anyone does want to pick up any of those issues with me.